Hello, good evening, and welcome. I am Samuel Trapp. This is International Flavor, and you are listening to Damn Radio. And I'm damn glad to have you. Damn without the N, of course, because we don't talk that way. And lots of news today, lots of things to discuss. If you wish to call in and harass me or have any commentary that you would like to share with myself and my audience here live or later to the audience that listens on my podcast, feel free to call on in and take what we have to offer and expand it. Put your own mind into it and say some more interesting things that we like to hear because it's good stuff. We want to hear it. We want to listen to your point of view. Last night we weren't sure whether my brother and I were going to be able to pull it off and have him be a part of the show tonight or not. As you know, I haven't been feeling all that well this week. Something going on with my crazy sleep patterns, and so I kind of begged him off a little bit for this week, and we'll renew our endeavors together next week sometime when it'll be a little better for both of us to discuss it with you. I wanted to talk about a few things today. There's plenty of news, plenty of things to talk about. And I had spoken a little bit last night about wanting to get back into the judicial discussions of licensing protocols in the state of Missouri, which I think are downright nonsensical in a lot of respects, at least when it comes to the legal profession. And nobody talks about this. You're not allowed to if you're a lawyer, so it's a pretty good thing that I'm on permanent suspended status. They don't disbar people in Missouri. That's too easy. It's they might be able to get their licenses back on some time. But if you suspend someone, you can have control of them for the rest of their lives. They can't do anything. You can't. So a lot of times you cannot apply in another state. Disbarred people, they can. Disbarred people, if you get disbarred in one state, you can go to another state, wait 5 years, and get reinstated. That's virtually everywhere. But if you're suspended permanently, like Missouri likes to do, and to destroy people, they can keep you on this hook. So you're not bad enough to disbar, which I'm not, but you're certainly bad enough to ever have a license again. And the threats of jackasses like Sam Phillips at the Office of Chief Disciplinary Counsel, who threatens you when he meets you and says, I'm going to make it so that you never practice law in the state of Missouri again, and you think he's full of crap. The fact is he's not, because the corrupt processes of the Missouri bar and these people who know how this system works can trash you. And I have my theories on whether or not the Big Bad Bar Association, which is called the American Bar Association, to see if the entire American Association has any sort of impetus in this. And wouldn't you know it, but this afternoon there was an interesting article that came out, and it was quite an interesting discussion that started. So I'm going to start with this. If anybody wants to talk on this topic, I'd be happy to discuss it with them. If anybody wanted to call and disagree with what I'm saying, whether it's somebody who's in the bar and believes that what they're doing is God's work or whatever they want to call it, or if it's, if I'm full of crap and that it's really a misunderstanding on my part or something that I am not an expert upon. Frankly, I'm more of an expert than most. Let's put it that way. But I'd be willing to be schooled if I'm incorrect. I have no problem with that. But I will defend myself, and I will ask you some serious questions, because there's a lot of things that are just dead wrong in the way our meaning our in Missouri, the Supreme Court on the Missouri bar and the BS procedures that they use. I said last night that the Missouri bar has no grant of authority from any source. Okay, there's no source in statutory regulatory law or in the rule-based law of the Supreme Court of Missouri, and there's just nothing there. So they don't have any authority granted to them in that way. So anyway, I think it's important that we discuss those sorts of things. But I want to read this other article to you first before I get in there, because something else interesting just happened on the national level. Here's the article title, and this was actually posted from a different source, but it comes to us from Fox News is where it came from, and it was put out somewhere else first, and I'm trying to remember where because I saw it somewhere else. Fox News Digital is where this came out. And I think it might be original there, but I read it somewhere else first. The title of it is called Justice Department Tells the American Bar Association It Will No Longer Comply with Ratings for Judicial Nominees. The letter, previewed exclusively to Fox News, marks the latest escalation in a protracted legal fight between Republicans and the nation's largest legal organization. And I'm going to give you the whole part. AG Pam Bondi accuses the district court judges of playing whack-a-mole with its anti-Trump lawfare. Okay, and that's a different. I'm hoping to see if we can find that and play it for you. I would like to do that, so I'm going to attempt to do that right now. And I've learned a new little trick that JR told me I needed to learn, and I may have actually learned it. And, so we're going to see if I can actually play this and if it says what I think it should say. It's 10 minutes long, and we're only going to listen to it until it gets to us. But it's one-on-one with AG Pam Bondi on Fox News Sunday. And so let us begin at the beginning.
The U.S. Supreme Court issues an unambiguous order and the president defies it. I think everyone agrees, or certainly that's a definition that I would embrace. That would be a constitutional crisis.
So that's Jeffrey Rosen of the National Constitution Center weighing in in this debate, how or when the U.S. ever gets to the point of an actual constitutional crisis. It's a phrase that some in Washington and beyond like to throw around amidst a host of legal challenges to the new administration. Joining us now is the person at the helm of most of those legal fights, Attorney General Pam Bondi. Welcome to Fox News Sunday.
Thank you. I'm so happy to be here with you.
Glad to have you. So let's start there. Is there any scenario in which the president gets an order or a final judgment from the Supreme Court in which he doesn't agree with it and he doesn't comply?
No, the president is going to comply with the law. He was overwhelmingly elected by an overwhelming majority of the United States citizens to be our commander-in-chief, and that's what he's been doing. Shannon, just since January 20th, we've had over 170 lawsuits filed against us. That should be the constitutional crisis right there. 50 injunctions. They're popping up every single day, trying to control his executive power, trying to control where he believes our tax dollars should be allocated. And saying he won by an overwhelming majority is so important because that's what the American people want. What President Trump campaigned on and what he won on. And he's implementing that agenda at a rapid speed. None of us can keep up with him every single day. And so it's just, we're going after all of these lawsuits. We're defending them all. We just got a great win, and we'll continue to fight every day.
You did. Friday night, 5-4 at the Supreme Court. You got a win with respect to cuts at the Department of Education. But the court did go against you on issues of foreign aid being paid out. How do you think these issues of executive power, when they get to the court, ultimately on the merits, merits will go? Because the court has told executives no when it comes to things like student loans or recess appointments.
Sure. I think we're going to be very successful on all these. So the one you just brought up, the DEI, that was Department of Education. So we represent all the various agencies, and all of these 170 lawsuits have to do with all the agencies across the board. This particular one, though, was very important because the court said that President Trump can control where our tax dollars go and what they're allocated for. And we do not have to spend them on DEI. And that's what was happening. So the ramifications of that are huge for our country, and that impacts every single agency. To give you an example of a case, Department of Defense. So it's military readiness, and that's one of the president's top agendas, as is Pete Hegseth. So in the district court, a district court in D.C. ruled against us on military readiness, meaning gender dysphoria, ruled against us. We appealed that to the circuit court, and we won. The second we won, within minutes, Shannon, in California, they filed an identical lawsuit, and we lost. So that's what we're up against. It's basically a game of whack-a-mole with these district court judges around the country who have a tremendous amount of power. They believe they do, but that's why we're appealing all of these cases, of course, up to the Supreme Court.
Yeah, they're very busy. So you have several things that are sitting there now. So while you had the win on Friday night, a lower court judge on Friday night ruled against you with respect to, and I'm going to read this because I want to make sure I get his name right, Kilmar Armando Abrego Garcia, who is somebody who was living in Maryland. He was under an order not to be deported because of fears or danger that he may face back in El Salvador. The government has admitted there was an error in deporting him. But this judge has said you've got a deadline midnight Monday to get him back from El Salvador. There have been allegations that he is a gang member, that he's involved in human trafficking. This is what the judge said. That's just chatter in my view. I haven't been given any evidence in a court of law when someone is accused of membership in such a violent and predatory organization.
That part's old. I don't want to hear that part. I only wanted to hear that first part when they were talking about the whack-a-mole that comes out when you're talking about it. And it was part of the beginning of this next part where they are discussing why this is somewhat important. And so, again, the title, the headline of this article is Justice Department tells the American Bar Association it will no longer comply with ratings for judicial nominees. And the reason is because these American bar people they have a huge impact on who gets picked to be a federal judge or how they are evaluated. The ABA does evaluations of these yahoos. They have to fill out applications to the American Bar Association. And American Bar Association has no authority, like I told you before. The Missouri Bar has no authority granted by any regulatory agency. They're not executive in nature. They may be quasi-agency related, sort of a quasi-agency. In Missouri, they've been held to be that way by a couple of different courts, that they have some kind of a quasi-agency power. But because they might be able to impact licensing of attorneys, but they shouldn't be, because that is also not granted to them in the way that it ought to have been. Okay. Everything else has a solid core of law behind it. A Supreme Court rule may be law because they have the right to regulate. The Supreme Court has the right to regulate the law, but they to regulate the practice of law, but they cannot delegate that right. They have to do it. Okay, because the bar doesn't have any power and hasn't been granted these powers in the appropriate way, but they have been seen as a quasi sort of agency. Okay, and the same goes for the American bar, but on a grander level. And so basically, when somebody comes up with a way to impact the practice of law, the ABA picks and chooses from all 50 states, picks these ones that, hey, there's a good idea. And then they kind of broadcast it down to the rest of the bar associations, right? So this article is important, and I want to read it to you. And this part came out, I think it was today. Yeah, it was published May 29 at 2:03 p.m. Eastern Time and updated at 2:36 p.m., probably for some spelling errors or something like that. The Justice Department on Thursday formally notified the American Bar Association that it will no longer comply with its rating process for judicial nominees. The result of what it argues is a biased system, and one that invariably and demonstrably favors nominees put forth by Democratic administrations. Now, as you're listening to this, you've heard me all complain about this nonsensical procedure that we have in Missouri called the nonpartisan court plan, which is actually worse than this. It's worse than what we're saying the American Bar Association's rating process, where they get to rate your judicial nominees. Who the hell is the ABA? Nobody appointed them to do anything. Nobody has given them governmental authority of any kind. All they are, they're not even a regulatory agency. They are just an association of lawyers, a bunch of what would you call them? Lobbyists. They're lobbyists. That's it. But they hold all the power in the legal profession on a national level, and a huge impact on who gets to become a Supreme Court judge, a circuit court judge, something like that. They play a huge role in it, and they get to find out and weigh in on every single federal candidate or for appointment as a federal judge. And the Trump administration today said, nah, we don't like that. Hell with you guys. Who the hell are you to tell us what we have to do as a presidential picking our potential nominees for the bar? This is how people like that don't get me started on that topic. I'll go back down the rat hole of the Judge Gregory Case, who tried to hold me in contempt so many years ago, and it was such a stupid story. But that guy became a federal judge, and in part because of stupidity like this. So I wonder what the American Bar Association little rating card says for Gregory Case. Or David Gregory Case, however he goes by these days. Anyway, the letter sent by U.S. Attorney General Pam Bondi to ABA President William Bay was previewed exclusively to Fox News. It marks the latest escalation in a protracted legal fight that Republicans have waged against the nation's largest association of legal workers. For several decades, the American Bar Association has received special treatment and enjoyed special access to judicial nominees, Bondi said in the letter. In some administrations, the ABA received notice of nominees before the nomination was even announced to the public. Some administrations would even decide whether to nominate an individual based on a rating assigned by the ABA, which is completely wrong. That's nonsense. The Department of Justice said in the letter that it will no longer grant the ABA the special treatment and first access it has received previously, revoking decades of precedent. Now, how in the world is that precedent? Where the ABA interviewed and vetted potential members of the incoming DOJ team. Accordingly, while the ABA is free to comment on judicial nominations along with other activist organizations, and believe me, the ABA is an activist organization, there is no justification for treating the ABA differently from such other activist organizations, and the Department of Justice will not do so. It also ended an Office of Legal Policy that directed judicial nominees to provide waivers allowing the ABA access to non-public information for nominees, including their bar records in the states where they, practiced, where they were lawyers or judges. Nonsense. Who the hell are these people? And by the way, again, none of them have any governmental authority of any kind. They are all part of a massive money grab and a huge lobbying effort, and they have taken the power just like the Missouri bar has done in Missouri. These are not the good guys, okay? They're not doing it to promote a good, a decent legal structure for the rest of the citizens of the United States. They are doing it to consolidate power. This is one of the ways how they continue to consolidate. If they get to have an impact on every single federal judge in the country, and by the way, the ABA and most bar associations in the country are heavily skewed Democratic, heavily, and I mean very heavily skewed Democratic. So nominees will not respond to questionnaires prepared by the ABA and will not sit for interviews with the ABA, Bondi said. Now, what previously gave them the right to do this? Oh, geez, they're the good guys. They're lawyers. The ABA, boy, it'd be very important to get their blessing on a judge, don't you think? Why? Why in the world would you want that? These guys they're not practicing law even. They've got full-time positions as lobbyists. That's what they got. And they make big money for doing it. Okay. And why are they doing it? To consolidate power. And who appoints them to the American Bar Association? Big money, big firms. It's not like it's you're finding good people to want to do something. These are huge money positions. The Trump administration's decision to excise the ABA from the judicial nomination process comes after several Republican senators on the Senate committee tasked with vetting judicial nominees told the ABA in a letter earlier this year that they plan to ignore the ABA rating system. The ABA, established in the late 1800s, has grown into an organization that touts a membership of over 400,000. But it has sparked criticism from Republicans, including members of the Senate Judiciary Committee. Senator Mike Lee, Republican from Utah, previously blasted the ABA as a radical left-wing advocacy group. They, and admittedly, that's not the right word, because they wouldn't admit it, but they are a lobbying agency. That's it. He and others on the panel, and power grabbers, he and others on the panel previously took aim at the group for embracing so-called woke initiatives, including its heavy use of diversity, equity, and inclusion, or DEI, in many facets of the selection process. This is not the first time Republican admins have broken with the ABA. The George Bush administration ended the practice of giving the ABA a first look at nominees, and Trump also did so in his first presidential term. Fox News has reached out to the American Bar Association for comment. But they're not going away, and guess what will happen? As soon as the Democrats are back in power, they'll throw these guys a bone and put them back on the hook to consolidate the power just like it needs to go. Here's some of the commentary. Great. Local elections have been swayed by the ABA endorsement of AGs, state Supreme Court nominees, etc. for years. Voters see those endorsements and in many cases don't realize they're voting for left-wing liberal candidates, even though they declare themselves nonpartisan. you know? Excuse me. Here's one from a guy named Cray Esquire. The ABA is thoroughly left-leaning. I maintained a membership as a new attorney decades ago. I left when the association grew consistently partisan. Like so many professional organizations, the ABA has surrendered to leftist progressives. In a few days, we will be hearing the left-leaning ABA is suing the DOJ to maintain their unfair left-leaning advantage. And rest assured, it will be filed before a radical left district court judge. Yep. The ABA and the AMA are both partisan NGOs with no priority to improve the country. Absolutely not. All they want to do is improve their own power. You know, it's nonsense. They are paid lobbyists and should never have any special access to nominees for any position. So here's somebody trying to change opinion to make sure we know what you are claiming is factually incorrect. And he probably should put Sam at the end of it. Lawyers self-regulate their own. And the ABA is an indispensable reason that legal profession still maintains its high ideals. All right, don't give me that crap. What high ideals? So you have a set of high principles. It's easy to have high principles, but you don't follow them. You don't follow them yourself. I could write all kinds of great things and say that, Sam is God's gift to the planet because he thinks the correct way. But Sam doesn't do the correct way. And so therefore, Sam isn't going to be, brought up to heaven in a chariot, ahead of everyone else, when he dies. That part's not going to happen. Okay. Remember that joke I told you last week about the one standing in front of St. Peter arguing? That'll be me. But don't think that any of these other a-holes are any better in the legal profession, because they're not. Judging them and acting like they're God's gift to the planet because they paid enough money to go get a sheepskin that said they were a good person, and then some leftist organization opted to let them stay in the practice of law and not target them, is nothing to be proud of. What's good to be proud of is the fact that you're a good guy, and that does not depend on a third-party left-leaning organization for validation. Unlike doctors, a non-lawyer cannot own a law firm and is not beholden to insurance companies. The ABA merely rates judicial candidates based on the ideals of the profession rather than radical non-lawyer groups seeking a loyalist for their cause. I disagree with that guy completely, by the way. I just thought it was nice to throw a counter point of view into the mix, perhaps, to see what excitement would come from it. And I was correct. And then there's still plenty of more plenty of more commentary on there. I've been a lawyer for 44 years. I canceled my ABA membership in the 80s because the articles in the ABA Journal became far more concerned with affirmative action, hiring, and diversity than providing actual practice pointers and legal news. The ABA has been way left for 4 decades. This is welcome news. And these are not the good guys, okay? And anyway, interesting topic, and it'd be different. I shared that because I want people to know that there are things that the old Trumpster is doing that is, that are impacting the system, the entrenched system of nonsensical nonsense which occurs in our country. But long term, again, it'll change nothing. As soon as the Democrats get back into power, business as usual. You're going right back into it. And certainly, I would like to see a great deal of changes in the practice of law, the selection of judges. Missouri is not your friend when it comes to that. And just because they create these high ideals does not mean that people follow those high ideals. And you have some pretty bad people. That Sam Phillips guy is not one of the good guys. Okay, that's a guy who goes out and targets people. He'd be like the equivalent of a prosecutor creating things to go after people for. That is Sam Phillips. He doesn't have any desire to protect the public. He wants to destroy people he doesn't like. And that is not. And then he can always claim he's not a government person, so it doesn't matter. He doesn't work for the government because he was appointed by the Supreme Court of Missouri to go out and attack wrongdoing lawyers, right? And so he has every right, and not because it was granted to him by the state, but because he's an independent who gets to go out like these ABA guys and rate and attack lawyers that he doesn't like. That's what it's about, friends and neighbors. So if you get on the bad side of these guys, what if you're a good judge and the ABA doesn't like you? I mean, in all seriousness, what's going to happen? What if you're a good candidate for judge and this ridiculous nonpartisan group of Missouri bar attorneys decides that you're not? And remember, there's 4 lawyers on this 7-person team and 3 civilians, they call them, appointed by the governor. And their job is to pick 3 candidates to present to the governor. Who do you think's going to win that war? You think those 3 people have any say in it at all? Do you think those 3 citizens of the governor that are not lawyers or may not be lawyers have any impact on that selection process at all? And these other people are going to tell the governor who he must appoint one of these 3, and if he doesn't appoint one of those 3, they pick? Oh yeah, that's a real good program. And people haven't in Missouri, in my opinion, paid much attention to that process at all. Because frankly, at this point, there's not a whole lot you can do about it. At this point, it's been, if I recall, it has been, turned into a constitutional amendment in the state of Missouri, if I remember right. And so they have seized that power for good in the Missouri, this nonpartisan league of I don't know what left-leaning bar a-holes gets to pick across the board who will be judges in most cities bigger than a certain number of citizens. Springfield is all done by this way. Kansas City, St. Louis, several other bigger cities in the state, and it's growing all the time. And they're taking on more and more power, and it is not right. If you'd like to talk about any of this, 573-746-8020. I get the 80, you get the 20. Once again, I am probably on a little bit of roll on that, and I'm a little grumpy about it, and I don't like it. But yesterday, I got to the beginning of my discussion on some of the licensing procedures. And I think that this is another area fraught with nonsense, especially on the lawyer side. And if there's any lawyer who wants to call out some Missouri bar yahoo who wants to call and argue this with me, I'm happy to learn why this is the preferred way to regulate attorneys. Yeah, this is the great way to regulate. It's like I read in that article to you, or the comments after I read the article to you. Some of those commentary, these pie in the sky dreamers that say, let's see, we're going to read it again just because the what you say. Remember, this is the quote from a guy. Truth and You Know It is the name of the person, and it was posted 39 minutes ago. So if he's out there listening, perhaps he can call me. What you claim is incorrect. Lawyers self-regulate. Okay, lawyers. How great does that sound? Lawyers self-regulate their own, and the ABA is an indispensable reason the legal profession still maintains its high ideals. Well, maintaining high ideals isn't saying that you're following the high ideals. It's saying that there are high ideals. Well, doctors have high ideals, do they not? Harm no person, first duty is to harm no one, and then, see what you can do to help after that, right? That's a pretty high ideal, isn't it? What do we got in the legal profession? Geez, don't rob from your clients. That's a bad thing. Oh, you think? So you think that high ideal shouldn't apply to a bartender? Let's say you have to have a license to be a barber. Wouldn't it be a high ideal to have a barber that doesn't rob his client? You can't pick any high ideal that the lawyer has that you couldn't apply to another profession equally and say, there's what it is, right? Oh, geez, no. And it's always twisted to something like, oh, we're taking care of the best system in the world, people. This is the best system in the world. And, even in law school, they pump you full of this crap and it's not crap that we have the best system. We should have the best system in the world. But the best system can still be inundated with crappy people. And that is the truth. You could go into any church on the planet, okay? And in that church are people who every Sunday go to church. Every Sunday they could stand up and profess their love of Jesus and the Savior and of all these things. And every Sunday they greet their neighbor in the best way possible. But during the week, they're out cheating on their wife. They're out robbing their neighbor. That happens all the time. You think, and I'm not saying that's 100% of the time, but there's always going to be a percentage of people who are yahoos. What difference does it make if they're lawyers? Just because they're lawyers, you don't know what's in their heart. You don't know if they're the people who are out trying to destroy other lawyers because they don't like them, because they're envious of them, because somebody told them to. Those things are all possible. And they do happen. They aren't out appointing judges because they have a certain letter after their name, R or D. They're trying to pick the best person for the job. That's what they're trying to do. And why wouldn't a governor be a better person to pick than 4 of 7, basically, lawyers that do not have that governor's interest as a person who's been elected to be there. They don't get to, why should they have more authority than an elected official? And who gave them that power? And if you read about the history of this nonpartisan judicial selection, it's really all we've done is swapped one set of corrupt a-holes for another. And why? Because they're lawyers and they have certain terms they have to live. You telling me that a doctor doesn't have standards? You telling me that realtors or brokers or loan officers or pick any financial planners, people that manage other people's money. You telling me that those people who are regulated, and they're regulated by the executive branch, you're telling me that those people don't have high ideals? I guarantee you they do. And so that is why I'm bringing up this topic. That is why this touches a sore nerve with me. And that is why, I talk about these things not as frequently as I used to, because they do upset me, because I don't like to think that our country or Missouri is run in the crappy way that it is run, because there are bad actors on the legal side of the fence. But there truly are. And the people who go out and attack people, small firm attorneys like I was, they'd never get away with it if they tried to pick the worst actor you could ever think of and have him be working at a large firm. If that firm don't want them coming in and talking to that guy or disciplining that guy, they'll never get in there. They'll never get in there. If that firm doesn't want to release any of their records related to that guy, that's never going to happen. And so the Office of Chief Disciplinary Counsel will never get in there. The rate of people who are disciplined in Missouri is strongly skewed toward small firm people because they have no choice. That's who they got to go after, is the small firm people that they can target and get every single record that they have. If you take a review of who they go after, it's always the solo practitioner or the very small firm practitioner that they go after. You won't find them going after the large firms. You'll never find them going after a government attorney. And you're telling me that there aren't any government attorneys that aren't evildoers? Nonsense. And so the system itself is not in good shape. And when the system itself isn't in good shape, how in the world and by the way, the system is also above question. People like me, you're not allowed to say things like I'm saying if you hold a license. If you hold a license and you say what I'm saying, you can lose your license for that. How do you like that? You can't talk bad about the system that you are a part of. Why? Because lawyers regulate themselves. And how do you regulate yourself? You never say anything bad about the system. Never. Right? The system is perfect, is what we're led to believe. Why? Because we're lawyers and we all think well. Well, if that's the case, and we believe that all doctors are on the good side, why do we let doctors regulate themselves? Why can't financial planners regulate themselves? I mean, they have the good of the public in their hearts, do they not? Don't these doctors have the good of the public in their heart? Why don't we let them regulate themselves? Somebody, as a state rep or as somebody who's listening to me, ought to put something out there even now to say, wait a second, Governor, wait a minute. You don't need to regulate these people through an administrative agency of the state of Missouri. They should regulate themselves. They should collect money from each and every doctor that is in the doctors know best what other doctors should be doing, don't they? I mean, how in the world does an executive officer from the governor, somebody appointed to run the Healing Arts Board or whatever it's called, how does that guy, if he's not a doctor, how does he know that that's the best thing? What if he's not a doctor? Does it have to be doctors regulating other doctors and the only way they get their power is for the executive branch to give it to them? Well, why doesn't the executive branch have to give executive power to the Missouri Bar? And the Missouri Bar doesn't receive executive power from any other source. They don't even get it from the Supreme Court, which is allowed to create its own rules, but none of the rules dictate that. We'll go through the rules one night when we go through this, but that is the Supreme Court has to regulate. The Supreme Court has to regulate. The Supreme Court regulated the Office of Chief Disciplinary Counsel. The Supreme Court created that and created regulations for how it works. But it's also according to themselves, I remember Sam Phillips when we would sit around and argue about it. I'd sometimes did it just to see him get all antsy about it. I would I would say, "Well, you're a state employee, Sam." "No, I'm not." I was like, "Sure you are, Sam." I said, "Who pays your salary?" "The Supreme Court." I said, "And what is the Supreme Court? Is it some kind of a state agency? Where do they get their money? Do they get paid by the state of Missouri? What kind of benefits do you have, Sam? Where does that money come from? But you get to claim you're not a state employee. And if you're not a state employee, how in the world are you regulating me?" He's acting on behalf of the Supreme Court, which is really weird, because if the Supreme Court is the person investigating you for discipline, how can the Supreme Court be the same agency that decides if you're going to be disciplined? If your authority comes from the Supreme Court and then you get to argue to the Supreme Court, that would never be allowed in a practice of criminal law, would it? Would it? Everybody claims, all lawyers get to be, "I'm an officer of the court." Yep, everybody's an officer of the court. Everybody has to apply with certain rules of the court, except the Missouri bar. The Missouri bar doesn't have any of those. They just don't have them. And so, at any rate, I could go on in that vein and I've probably gone on in that vein for too long already. And I want to get to some of these licensing issues, because they are quite interesting, at least to me, in how they come out. So I told you yesterday that I did a bit of a review and a search for how different professions get their licenses in the state of Missouri, and I stayed specifically in the state of Missouri for this. And it for me, it seemed like a good thing to review with that when that article came out. The one that I read to you earlier, or talked to you about earlier, it seemed a good segue into it on the judicial side, because I'm not alone in thinking this way. If people from the Trump administration think that way, now, isn't Pam Bondi a lawyer? I don't recall, to be truthful, but I think so. I mean, wouldn't there's be a bunch of lawyers up there in the DOJ, and so they started out as lawyers if they're not, and I'm 90% certain that they are. Well, how come they're allowed to question these things, and I'm not? Well, they're in that position where they can say these things, right? They're in positions where, I don't want to say they're untouchable, but that if they make enemies, it's not going to be enemies that come after them for their licenses. I mean, think about this. I hate to turn it back to me, but I lost my license over 4 reasons in Missouri. 4 reasons. The first was failure to communicate with a client who I hunted down for months, and she refused to take my calls, refused to meet with me. My secretaries and assistants tried to find her and get something done, and she wouldn't do it, and she wouldn't talk to me. And then I was found to have failed to communicate with this client in the end. And what they chose to believe her over me. I get that. Okay, that was, that's part of the risk. But that's number one. And lawyers get accused of that stuff all the time. Think about when you have a lawyer and whether that lawyer calls you back the same day or not. Okay, how long do you go without hearing from your attorney? If there are people out there who have ever had an attorney and that attorney is instantly available all hours of the day, that's now I was available all the time. My phone would go off and I would answer it, and everybody had my cell number and whatever, and I did everything I could to try to be available to people if I could be. And so I was a bit offended by that result, because I had two assistants testify that their efforts, my efforts, our efforts to get a hold of this lady, and they chose to believe her over us. Okay, fine. I get that. That's number one. Number two was, and this is perhaps the biggest, was I potentially intermingled my funds, my own personal funds, with my trust account funds. Now, at the time, the laws allowed me, or the rules allowed me to do what I was doing. And they changed them all after me. They changed them all because I made very good points in going through it all as to what it was. But now you're no longer allowed to do what I did. And so I was investigated, and they went back 3 years in my trust account to find these when they started to come after me. They went back 3 years in my trust account, and they said, you have to provide us, here's the day of April 10th, 3 years ago, and you have this transaction on this day. You took $10,000 out of your out of your trust account and transferred it into your business operating account. What's that $10,000 for? And the error I made was in not having detailed enough descriptions of where that 10,000 exactly where it came from. So, but our practice was that we would on a every Friday, every other Friday, we would kind of sit in a room, and we always were at a bar or a restaurant, in a meeting room, having meetings on Friday afternoons. And we would sit there and talk about where each case was and where. So every Friday afternoon, that's what we did. And we would go off site, and all the staff would be there, and we would go over every single case that we had and say, here, well, what's this guy? And so we would kind of percentage where this case was. And once it was near the end, we would take all the money that person had paid us that we had put in the trust account and swap it over. But we did it in one transaction. So if I swapped over $10,000, that could be money from 10 different clients, right? But I never kept good enough records of exactly who it was. No client ever claimed that we stole their money. No client ever claimed that anything was missing. Zero, nothing like that. But I couldn't produce these records. And so that is, by definition, potentially intermingling my own money with that of my clients, which is against the rules. I'm fine with that. I get it. I did it. I should have kept better records, right? And that's now they've changed all those rules. You cannot do what I did. You now have to, for each and every client, when you transfer money, it cannot be done electronically. It must be done by a written check specifically for that client. So if the client paid you $1,000 and you put it in your trust account and you take that money when the case is over, 10 days later, the case is over and you've finished and you've earned that money now because it sits in your trust account if you haven't earned it yet. Now you can write that check over to yourself. It's a separate trust account check from the trust account check to you in the name of that employee. But the BS of it all is as follows. You're also not allowed to do part of the work and not take the money. So let's say that on the first, that you charge $1,000 for a DWI, and this DWI, you put the money in your trust account. 3 days later, you go to court for a first appearance. You chat with the prosecutor, and you've done all that. You've done part of the work. You now have done part of the work. Part of that money is now yours. You have to take it. Otherwise, you've intermingled your money with the trust account, and now it's your money. You have to go back, say, geez, I worked 3 hours on that case out of 10, and so therefore I need to take 300 of it right now. And nobody does this. Nobody does this. There ain't a soul on the planet that does this. And so and any lawyer in the state could have been gotten for the same thing that I did. And so I guarantee you that most people are trying to figure out how to comply with this nonsense. And each time you have a different client in a different case, they've created these impossible rules that nobody can follow, but the people they go after are Sam Trapp, right? And I'm not alone. They've gone after a few other ones. But so that is reason number 2 that I was disciplined. I should have been disciplined for that. Okay. And arguably, even for the first one, fine, give her the benefit of the doubt for the client that I didn't, communicate well enough with. Okay, maybe I should have driven to her house. I don't know. Maybe I could have done more, to do something for her that I didn't do and I should have, perhaps. I don't know. But either way, those 2 I'm okay with. But get these, number 3 and number 4, which are both identical. On 2 occasions, Sam Phillips called me and my lawyer at the time, a guy named Doug Barding, and said, listen, this April 10 transaction we were talking about from problem number 2, you have to tell us who that's for. And they'd say, tell us that $10,000 that you had, break down for us who that is for. You have to tell us. And I was like, well, I can't. Well, but you have to. Yes, but I cannot. What do you do if I cannot? And they said, no, you must. I was like, well, okay, I cannot. Well, I was charged with one of the things that I failed was in failure to cooperate with the investigative authority 2 times, because they asked me to do this twice for 2 different dates, and I couldn't give them the information for those 2 dates. And so that is not cooperating with the investigative authority and they would say, well, you have to tell us. I said, no, because then if I guess and I tell you something and I guess it, you're going to say that I lied about it. Because there ain't no way I remember what happened 3 years ago on this particular day when I transferred the $10,000 over and which particular clients that applied to. I have no idea. Nobody ever did. Somebody complain that I stole money from them? Is that what you're after? Then fine, produce those people who say that I robbed them and let's go. But I'm not going to go out and create something that you can turn around later and go, yeah, but you said, you'll have a forensic accountant come in and go, well, it can't be that way. And it's like, well, I'm not going to make it up for you. I'm not going to. Now, they charged me with 15 things initially, and then they dismissed 11 of them. No, I'm sorry. They dismissed 10 of them, like a few days before trial, because they couldn't prove any of them. And and I didn't do them anyway, but they dismissed them all. And then I was after 5 things. One was I allegedly stole my client's property, right? The same thing I've talked about that Greg Williams did, that I sued him for on behalf of a client. He sued me for the exact same thing with a different client later. But I didn't take my client's property. I took my client's mother's property. And so I felt completely fine and justified in taking my client's mother's property. And when they wanted me to admit to that, and say that if I admitted to that, then I could probably get something. I probably should have. Hindsight's always 20/20. If I had admitted to it, maybe it would be okay today. It's not, and so I get to tell these stories about exactly what happened. It's freaking nonsense of what occurred to me. But I was disciplined for 4 things because the Supreme Court ruled in my favor on the property thing, of course, because it wasn't his property. It was his mother's property. So I didn't take my client's property. I took my client's mother's property. I mean, what more do you need to know? And why would you proceed to go after somebody knowing full well it wasn't the client's property? It was the client's mother's property. Well, here's the genius, the legal genius of Sam Phillips was that, well, he lived in the basement. He lived in the basement. I said, no, he's lived in jail for 2 years. That's where he is. He's in jail. Yeah, but his room was in the basement. Well, his room was in the basement when he was 11, too. Does that still mean he's got an interest in his basement when he was 11? Does he still hold that interest until the day he dies? My mother still has the house where, I had a bedroom. Does that mean that my mom can never sell that house because I have a bedroom in it? Nonsense. It is horrible lawyering, by the way. And it doesn't take any legal genius to figure that out. And everybody knew. I can't imagine he didn't know that the Supreme Court was not going to rule in his favor on that one. But they ruled in my favor on the other three. Now, nobody ever loses their license for the four things that I've just outlined to you. But Samuel Trapp did. Why? Because. Just because. Whatever it was that I had done to offend the world was a pretty big deal. And I believe there were machinations and all kinds of evil doing in the back halls, shall we call it, of the Missouri Bar, the Supreme Court, the courts in general, and I had made a lot of enemies along the way. And so I believe that that is what happened to me. And you don't lose your license forever for that. None of those are disbarable offenses, not a one. And there are many, many lawyers who have done those things and nothing has happened to them. But if you're Samuel Trapp and you have a radio show where you talk about these things, which I did from 2008 until, I don't remember, 2013, I think, right before I got to the, I was under the attention of the Missouri Bar for a while. During that time, it was, I think I did that show for a good number of years. And at any rate, that is the story of how that occurred. And so the regulation part is part one of that issue, because remember, it's only the lawyers are the only profession in Missouri and anywhere else that regulate themselves. And it's all based on these pie in the sky things, like this guy says about the ABA being indispensable reason that the legal profession has high ideals. Nonsense. Okay. So what we're going to do is we're going to look at the statutory authority in Missouri for a lawyer to have a license is the Missouri Supreme Court, right? That's the state authority. The Missouri Board of Law Examiners, okay? And the Office of Chief Disciplinary Counsel. Each of these are state or they have rules that apply to them from the Supreme Court, okay? You have to have a Juris Doctorate degree from an approved ABA. Here's an American Bar Association approved school. So the American Bar Association is so embedded into this that they're the only ones that can approve a law school. Now, many, many years ago, actually, it wasn't even all that far back. In the 80s, they still had some. They had places that allowed for on-the-job training for a number of years that they did allow. And so this tells you the education that is approved. There's an application process. You have to register to take the Missouri Board of Legal Examiners. You have to let the school know, or you have to let them know after you've started law school if you plan on applying in Missouri. And you can apply online to take the Missouri Bar, okay? And the approval timeline, a character and fitness review for a new lawyer is 3 to 6 months, depending on the complexity of the background. However, if you're trying to come back into the practice of law, mine was delayed the first time on purpose with absolutely no reason for 18 months. So I applied. The guy sat on it. He didn't touch it. He didn't send out document 1 for 12 months. And then he did some sending out of some documents after my lawyer harassed him after a year. When I called, he told me to get a lawyer and said, this is how it goes. And then, but normally it doesn't take any time at all. 3 to 6 months is the longest it ever takes, right? And then it tells you how you can go about. Ineligibility to practice law says any pending felony charge or conviction of a felony until the conditions of Rule 8.04a and b are met, which are completion of your sentence, probation, or parole. So even a felon can get his license to practice law in Missouri. And in fact, there are lawyers who have committed perjury in front of a judge, lied under oath, lost their license, gone to prison, served their sentence, come out, applied to get their license back, received it on the first tryout after just a month or two. But oh no, those are felons, right? I'm not a felon, You're ineligible if you are on suspension or disbarred in another jurisdiction. Or if you're denied an application in another jurisdiction due to character and fitness. So there you go. So that is how the Missouri courts regulate attorneys, okay? And by the way, most of that is done by other lawyers and not through, through any other process. That's how it goes. So the second one I picked just for fun was a barber, because I talk about barbers and see if they have high standards. So to be a barber in Missouri, you have to the group with the authority to grant you a license is the Missouri Board of Cosmetology and Barber Examiners and the Division of Professional Registration. And by the way, this is an executive agency subject to the governor. The governor appoints who regulates this, the administrative hearing committees and blah, blah, blah. They have 1,000 hours of training or 2,000 hours as an apprentice under a licensed barber. Then they have to pass written and practical examinations administered by the board. Okay. The application steps: submit an application, provide proof of training, pay an application fee, $50 or so, schedule and pass written and practical exams. The agency is Missouri Board of Cosmetology, and the approval timeline is only 4 to 6 weeks. Okay. 2 to 3 months from application to licensure, assuming you pass your exams on the first attempt, right? You can be disciplined, but you're not disciplined by other barbers. You're disciplined by the board. This board is who comes after you, okay? And you have criminal convictions. They can come after you if you have a felony or something. You can do that, and they can file their own complaints. The board investigates and may issue a warning, hold a hearing, or refer to the Administrative Hearing Commission. The appeal process, if you lose at the Hearing Commission, is you appeal to the circuit court, usually in Jefferson City, Cole County, within 30 days of the board's decision. Then another appeal can go to the Missouri Court of Appeal. So as a lawyer, you don't really get that. There's another group, and get this. So as a lawyer, they have the same process. The Missouri Bar selected group of people who they pick a 3-person team, to go and decide, that these people get to hear your claim under no real legal proceedings. They don't follow administrative law. They don't follow any of that stuff. It's a separate little group, and the hearing process is somewhat lax, okay, for them, because these are not administrative agency people. They are not people who they're only appointed for this particular case. So they go out and select 3 people by the Missouri Bar, by the way, who get to figure out whether you've done something wrong, and the only place to appeal to is straight to the Supreme Court of Missouri. And so that here at the for a barber, he gets the board first. If the board makes a decision and he don't like it, he gets to go to the Administrative Hearing Commission. If the Administrative Hearing Commission makes a decision and he don't like it, he gets to go to the Circuit Court of Cole County. If he doesn't like the decision by the judge in Cole County, he can then appeal to the Western District of Missouri Appellate Court. And if he doesn't like that, then he can go to the Supreme Court of Missouri. And if the timelines aren't in a reasonable time, if they left his application sit out for 18 months without a decision, without doing a damn thing, and just said that they would have the governor's head for allowing that kind of thing to happen, and there would be law imposed upon them to say, you can't leave this sit out there for 18 months. You have to say something within a reasonable period of time. But they don't do that for lawyers. Why? Because they don't want you back into the practice of law, and if they can delay it, they win. You can't survive that long. And the first time I reapplied, it was 18 months and they didn't touch it. The next time I applied was 26 months later, and the guy submitted the exact same documents that he submitted at the first time. He didn't do anything different. He submitted the exact same paperwork 26 months later. Don't you think that is somewhat of a broken system? Would you put up with that in any other licensed profession, whether it's barber or whether it's the next one? Let's talk about a bail bondsman. Okay? A bail bondsman is given a license by the Missouri Department of Commerce and Insurance, right? They have to complete 24 hours of basic training in bail bond-related subjects. They have 8 hours of continuing education, biennial continuing education every other year. They submit an application. They pay an application fee. They undergo a background check and fingerprinting, and they have to obtain a surety bond or proof of employment by a general bail bond agent. Okay. The Missouri Department of Insurance accepts the fees. The approval timeline, again, 6 to 8 weeks, including the background check. Total time, 2 to 3 months from start to finish, from the time you enter to the time you get off. Grounds for discipline: use of controlled substances, fraud, failure to comply with court orders, unlicensed practice, and or criminal convictions. And again, they have a division of insurance, and I did a couple of these hearings when I was practicing law. You can go up, you get accused of something, somebody files a complaint with the division can investigate and issue a warning, hold a decision, make a hearing, and come with some kind of decision. If you don't like it, Administrative Hearing Commission. You don't like that, you appeal to Cole County Circuit Court. You don't like that, Western District of Missouri Appellate Court, and then Supreme Court of Missouri. And I guarantee you, appeal process. File a complaint with the Administrative Hearing Commission, decisions to the Circuit Court within 30 days. Okay? And there is... if you're suspended, a suspension agent can apply after the suspension period is over, showing compliance with division orders and education requirements. A revoked license would require the reapplication as a new applicant, but they're not excluded. Okay, and there are all kinds of statutory provisions: RSMO Chapter 374, 695. Through a bunch of others for bail bond agents. They have insurance rules because they're Department of Insurance related. You're ineligible, or can be, conviction of a felony or crime involving fraud. So you can have other felonies, and even the fraud can be waived under the Fresh Start Act. Okay? But as a lawyer, you can't waive anything. They apply new rules. They create their own rules on the fly over there, and there's no appeal to anywhere. And you can't bitch that it took 26 months for them to hear your case because there's nobody to listen to it. You can't do anything about it. Real estate brokers. Now, I'm a real estate broker. Let's see. I'm a broker both in Missouri and in Florida. And so I have to hold a Missouri real estate license in order to become a broker for 24 of the last 30 months. You have to complete pre-training. You have to complete 12 hours of continuing education every other year. You submit your application within 6 months of completing the training, the education. Provide proof of your experience, pay a fee of $75,000, and pass the Missouri real estate broker exam, right? And you're regulated by the Missouri Real Estate Commission, right? Another regulatory agency run by the governor, executive branch, right? The grounds for discipline: fraud, misrepresentation, unlicensed practice, or criminal conviction related to real estate. Okay. Who can accuse you? There are plenty of people. The complaint is filed with the commission. The commission can have a hearing, make a decision. If you don't like it, where do you go? People, we know where we go by now. You go to the Administrative Hearing Commission. And the Administrative Hearing Commission, if you don't like that, the commission issues a final decision, but it's not final. If you don't like it, where do you go? Circuit Court, Cole County. There you go. Further appeals, Missouri Court of Appeals, and then Supreme Court of Missouri, right? Suspended brokers may apply after suspension is over, right? Revoke license requires reapplication, including new education and new exams. So even those who are revoked can get their license back in Missouri. Statutory provisions set by the legislature, RSMO Chapter 339, right? And are you seeing a pattern here, people? I wanted to get to a couple that are pretty high level. Now, we all know that doctors are important and spend a lot of money and are, they're very valuable to us. And doctors don't regulate themselves, as we have found out. They're they are by who? Missouri Board of Registration for the Healing Arts. That's who regulates them. Again, executive agency. Applications to process take 8 to 12 weeks, including the background check, right? And so once you've got all your education processes, within 3 to 4 months, you can become a doctor with a license in the state of Missouri. You can be disciplined for incompetence, misconduct, fraud, criminal conviction, right? Again, what happens if somebody has a complaint? Exact same procedure. Are doctors and lawyers, are doctors less important than lawyers? Why can't they regulate themselves? I don't understand that. Why can't barbers regulate themselves? Why not? What's so special about the practice of law? There's nothing special about it. You have education, you have the rules, but we've bought into this fact, or what we like to think is that we are so much more important than the rest of the planet just because we are lawyers, that we have a self-created, alleged higher standard that is anything but a higher standard, okay? It'd be different if it was, but it's not. Let's start with a title company. These are people that handle other people's money, and they should have special rules that apply to them. Somebody tell me what makes it so important that lawyers regulate themselves. And you really cannot come up with a valid answer. You just can't do it. And there are a number of states that do regulate attorneys statutorily. And so it doesn't have to be only by the Supreme Court. It could be only. I'm asking a question of the AI model here to see if I can name the states that regulate only by statute. I want to say California is one of them, but I don't recall. What states regulate attorneys only by statute and not by court rule? And we will see what that says. And if that is the case, let's see. Well, states with significant statutory regulation. Number 1, California. Number 2, Louisiana. Number 3, Nevada. Number 4, South Carolina. and it's still going. So, well, no, just those two. States with no statutory regulation. Number one, Missouri. No statute. It's with zero, no, nothing at all. Missouri. Some states rely heavily on court rule, with statutes playing a minimal role, typically limited to criminalizing unauthorized practice. Missouri. Supreme Court of Missouri regulates attorneys through Rule 5, which is discipline, Rule 8, which is admission, and the rules of professional conduct. Statutes primarily address the unauthorized practice of law and basic licensing requirement, but the court's inherent authority is the paramount concern in Missouri. So, nonsense. The Supreme Court of Wisconsin also is the only other one that regulates only by the court. And the Wisconsin Supreme Court defines and regulates the practice of law. And the statute, which is only one chapter, provides limited support for unauthorized penalties, and that's it. So Missouri and Wisconsin are the two. And Wisconsin is one state where you don't have to take a bar exam. If your schooling came from the state of Wisconsin, like if you went to, University of Wisconsin Law, you instantly become a lawyer in Wisconsin. You don't even have to take a bar. I had a girl that worked for me for a while as a lawyer when she had just gotten out of law school, and before she'd take the Missouri bar, which she failed, but she went back to Wisconsin and became a lawyer up there. Actually, you know what? I shouldn't say that. I don't remember if she ever ended up taking it. She might have gone back before she took it, and so I don't want to say that she failed when I'm not positive that she did. But the ones that regulate are there. The rest of them are somewhat hybrid, and where they go to and from, but they have significant rules. And here's what the statement comes in, and why everybody thinks that the practice of law is so different than other places. You tell me whether you think this makes sense to you, okay? The regulation of attorneys in the United States is typically a hybrid of court rules and statutes, with state supreme courts generally holding inherent authority, right? Means self-granted authority to regulate the legal profession as officers of the court. Those are always key words, right? While legislatures can enact statutes to codify certain aspects of attorney regulations, such as licensing, unauthorized practice, or discipline, no state regulates attorneys exclusively by statute without any court rule, as the judicial branch has inherent authority over the practice of law, and that's a well-established principle across all U.S. jurisdictions. And I would argue because of the American Bar Association, they take that position, but there's really, in modern world, no reason for that, okay? There's just none. And nobody can back that up and say why. They just say this is how it is. They don't say that it needs to be that way. And where no state regulates attorneys exclusively by statute without any court rule. Some states rely more heavily on statute. Let's see. Why no state regulates only by statute? And I found this interesting. The practice of law is intimately tied to the judicial system, and state supreme courts have historically asserted their own authority to regulate attorneys who practice before the court. This principle is rooted in the separation of powers and has been affirmed in cases like ex parte Secombe in 1856 and in reintegration of Nebraska State Bar Association in 1937, which emphasized that courts, not legislators, have primary authority to define and regulate the legal profession. Okay? So, but who made those decisions, of course? Courts. And so courts, they want this power on their own, and they want it. Court rules as primary mechanism. State Supreme Courts typically promulgate rules governing attorney admission to the bar, rules of conduct and discipline. These rules are often codified in court promulgated rules. Statutory role. Legislatures enact statutes to regulate specific aspects, such as criminalizing unauthorized practice of law, establishing a bar association, or setting a licensure fee. These statutes are subordinate to court rules and do not override the judicial's inherent authority unless the state constitution explicitly grants such power to the legislature, which is rare. In most states, constitutions vest the judiciary with authority over court administration and the regulation of attorneys. Arkansas Constitutional Amendment 28, Colorado Constitution Article 6. Even where statutes exist, they must be consistent with court rules or risk being struck down as unconstitutional on judicial power. And again, there are several that are have regulatory frameworks. When I was researching this, California is definitely the heaviest, and the state bar's board of trustees is established there by statute, and it handles the administrative function. But the Supreme Court reviews disciplinary recommendation and admits attorneys to practice. Okay, but at least they have rules. In Missouri, they just change them on the fly when they don't comply or they don't comport with what they want to do in a certain case. You don't have to follow rules if you don't want to. And Missouri does not, at least they did not in my case. The rules do not matter in that case. And they follow things that are not in the rules. They follow the Missouri Bar. So they create these other agencies or organizations that have nothing to do with anything in the rules, and they don't even follow their own rules. And that is what I'm complaining about, ladles and jelly spoons. And that is unfortunate, because I want the practice of law to be what I thought it was in my youth, to be the good guys like I thought it was and should be, and it's not. And that is certainly unfortunate, because it's just wrong, that things are allowed to take place outside of the rules. It's truly unfortunate that is the case. And anyway, I think that would be about it for this evening on where we're going to go. I appreciate each and every one of you for listening to the show tonight and for being with me once again as I ramble and carry on like a madman and say the things that I like to say, and do the things that I like to do. And so I wish you all a pleasant evening as we wind down and get to where we are going. And I encourage you all to, this is, this is my last one of the week, isn't it? This is my last show until Sunday night. I appreciate you all definitely for joining in And I certainly hope you come back. If you would like to listen to any international flavors on the podcast, all you got to do is go out to internationalflavor.com and you can find the old podcasts out there. And you can also go to damradio.com/podcast and listen to them there as well. And I would appreciate it if you do. Once again, I very much appreciate each and every one of you. Oh, by the way, you can go and check our schedule at damradio.com/schedule. Hope you all have a good evening. Good night.